Nice to see everyone. Happy Friday. It was supposed to be a miserable day out there, but it turned out to be a nice day. Hopefully it stays that way for another, 30 days or so. And we can, I'm not even going to say what budget we're trying to save right now because it might jinx us. But hopefully your budgets are okay so far, so good. So welcome. And today's topic, I don't actually have the name of the person, but this was a requested topic today. I've touched on a lot of these issues over the past several years, but it was a requested topic, and it's the intersection of board member and manager duties and powers. So the first thing, I have to do these legal lawyer disclaimers every time, is these webinars are provided for general informational purposes only. These webinars do not and cannot form an attorney-client relationship. The information exchange does not constitute legal advice. To obtain legal advice, you have to make contact with an attorney directly, either with a written agreement, and present your particular facts. No information discussed during these webinars will be kept confidential. So I stayed with this topic because it was a requested topic. I will, and if you want to provide me some feedback on this, this is fine too. I will probably be discussing the first of next month, either ChatGPT, if anyone's familiar with ChatGPT, which is a software program that's coming out that allows people to write certain things and do certain things very easily, including but not limited to legal contracts, legal resolutions, and things like that, and to talk about how we think that will probably impact the legal community and the association community. And also, I have on the list, which is a current event, the CIL City unfortunate deck collapse down there, where a gentleman was killed last week in a deck collapse. And in line with that, the pending legislation, which was introduced long before that collapse, Senate Bill S 2760, which is aimed at, it was basically a response to the Champlain Towers catastrophe. But S 2760 is New Jersey state law that is aimed at inspections of both new buildings and existing buildings on a regular basis with respect to structural integrity, as well as touching on issues with respect to reserve funding, additional maintenance issues, and to a small extent, borrowing, as well as board powers when the association has to address structural issues, but the governing documents may require a membership vote to do that work. So in the next month or so, I'm going to be talking about those two issues. And again, you can provide me some feedback of which you would prefer. Senate Bill S 2760 has moved somewhat. It has bounced around one or two committees, and I believe it's in a third committee now. So it is something that I think will move. So we'll see. It is kind of a hot topic, especially, like I said, given the CIL City situation last week. What else do we have? Dog of the day. So we had 3 dogs of the day. 3 dogs of the day. That's okay, but Eileen's going to show us the dog of the day. Mm-hmm. And that is Molly. My God, what a cute dog, right? So that's Molly, and she belongs to Mary Scheibner from the Mews at Laurel Creek down in Mount Laurel, New Jersey. And she's an Australian Labradoodle. Beautiful dog. Thanks so much for sending the picture in there. And I'm sure, I hope you're on with us. I didn't see your name come up, but I hope you're on with us. There she is. Hey, Mary, how's it going? So we'll jump right in. And if you have any questions, as you know, just post them in the chat and we can talk about them. There was one footnote. Somebody had sent a question over ahead of time. I'm going to just touch on that real briefly before we get into it, because otherwise I'll forget. Someone asked, totally off topic, was can an association do a license agreement with the association next door so that the people next door can use their swimming pool? The answer to that generally is yes, but there are many issues you have to think about. I'm not going to go crazy about it now, but a few of them are, number one, insurance issues, risk management issues, whether or not it makes your pool a public accommodation rather than a private accommodation. So you have to get insurance professionals involved, your legal professional involved, as well as your accountant, because if you're charging fees to have a neighboring association members use your pool, that would be non-member income as to your association. So typically that would be taxable revenue. So there are risk management issues there's tax issues and a number of other issues. So it's doable, but you have to do it the right way. Otherwise, you're going to get yourself in trouble, especially on the insurance front. So thanks for that question. So the sources of duties and powers with respect to board members and manager duties and powers. Okay, so you have statutes and regulations, right? We've been talking about Radburn for a long time. We've been talking about PREDFA. We've talked about the Condominium Association, Cooperative Recording Act. So the statutes and the regulations themselves are typically a source of powers and duties for the board. So typically those statutes and regulations do not specifically reference and the management company shall and the manager shall, right? It's always laid off on the board, right? Because as we know, the buck stops with the board, not the management company. It stops with the board. Notwithstanding that, what virtually, not every, but most associations that we work with have either a management company, a management representative, an in-house manager, or sometimes it's actually a member of the community in self-managed communities that do it rather than the board themselves, right? That perform the duties specified in the statutes and regulations. I had a bitter disagreement with a gentleman in Ewing one year who they had a professional management company, and he said the governing documents specify that the board shall be responsible for keeping the books and records of the association. And he was the treasurer, and the treasurer specifically says that they're responsible for keeping the books and records of the association. Therefore, he must do the books and records rather than the management company's bookkeeping staff. I 100% disagreed with that, but he had more power on the board than I did, and he got me fired. Now, I don't know why in the world he really wanted to keep the books and records himself, but he did. And they wound up keeping basically 2 sets of books because the management company was not going to let him be the sole keeper of the books, of course. But for whatever reason, he wanted to do it himself. So the statutes and regulations, again, put the duty on the board. The board hires a managing agent to implement the day-to-day duties, right? To take care of the day-to-day duties, to exercise the day-to-day powers for the most part. So that's statute and regulations. Then we get into the governing documents, the master deed, the declaration, the certificate of incorporation, the bylaws, and the rules and regulations. So as you know from our discussions in the past, the master deed and declaration generally outline property rights and restrictions, whereas things like the certificate of incorporation, the bylaws, rules and regulations speak to things like how the board should act, what the board should do, what votes are required, things like that. So the powers and the duties with respect to the board are often mostly laid out in the bylaws rather than the master deed or declaration. Oftentimes, as I said, developers' attorneys reflect them in both, which is not always helpful because often they're inconsistent. But those powers and duties are usually listed most expressly in the bylaws. The rules and regulations can be passed by the board, but those powers and duties discussed in the rules and regulations and things like resolutions have to be within the scope of the bylaws, right? So a rule and regulation adopted by the board can't give the board more power than the powers granted by the bylaws themselves, if that makes sense. Does that make sense to everybody? The board just can't go crazy and just make up its own powers. Oh, there's Sue Perloff. Long time no see, Sue. Haven't seen you in a while. Hi. So that's the governing documents. And I wanted to take a brief detour here from the agenda to talk about resources on community association issues involving board member duties, board member powers, and the management, the interaction of those things. So I'm going to share screen for a second. I imagine most of you, since you're so active and you're kind enough to attend these webinars, you're familiar with this, but I will show you anyway. So this is the Community Associations Institute website. People get confused with CAI or the Community Association Institute. The website I'm on right now is the Community Association Institute's national website. This is not the New Jersey Community Association Institute's website. So you would have to generally search Community Association Institute, and typically the first thing that would come up would be the national website rather than the New Jersey website. This is the library, if you will, right? So I'm sorry, the bookstore. So if you see the website, it talks about the chapters of the Community Association Institute, advocacy, which generally involves legislation, learning center, which is courses, etc., resources for community managers, homeowner leaders, which is generally board members and committee members, and business partners are generally vendors like myself and other vendors for the community. But the thing we're talking about today is the bookstore. So if you go up and you see the bookstore, we're in the bookstore right now. We're in the section under management. There are wonderful resources for both managers and board members on management and administration of the association at the board level and at the management level. So for example, and I'm not going to stay on this long, I just want you to be aware of it. For a relatively small amount of money, you can buy, for example, a book, Managing and Governing Associations, $20, right, for members. It's a guide with overview of the various aspects of managing associations, etc., how they function. And there's another one in here by Cliff Treese, who is, he is the hardest working man in community association world. I think Cliff is living in California these days. Good for him. But he has another resource in here. I'll give you an example. Self-managed associations. If you're an association without a property management company or a professional property manager, this is generally with respect to smaller communities that are really run by the board, which is generally rare, and I don't love the idea. But we have a few clients that's the way they work. But generally, there are many, many resources in the Community Association Institute's bookstore that can inform the association on things like, what is the role of management? What should I expect from management? Can I expect the world from my property manager? Probably not, right? And if I do expect a certain level of service from my property manager or management company, what should it be dollar for dollar? Because many management companies will have very varying prices when they bid for management services, but you have to make very sure that you're comparing apples to apples. And I often get in discussions with boards about a new management company they may be bringing in, or a management company that they may be letting go because they think they're going to save big dollars by bringing in a new management company. And really all they're doing is they're trading down. Right? So somebody comes in and makes them lots of promises, and unfortunately, they don't always deliver. So you have to keep in mind, in the management services world, you are comparing apples to apples, and you know what you're getting going forward. So the CAI Community Association Institute bookstore is an excellent resource for that. One thing that I will say is, with respect to the CAI bookstore, this is just all background, excellent learning opportunities for all of the people who are committee members and board members, as well as the managers that are on the webinar. But from either side, whether the management side or the board side, these tools should not be used as gotcha moments. Like, hi, Fran McGovern, could you tell me how resolutions really work? And then I say that, and they go, well, let me tell you what the Community Associations Institute guidebook says. Because as you know, unfortunately, there are a lot of cute people in our communities that will do that. I don't expect any of us on the call today would, but there are people who do some interesting stuff. So another source of duties and powers is the management agreement itself. So a lot of board members, when they are searching for management services, they interview the potential management company and potential manager, and they talk about all kinds of stuff, wonderful things. And then we get a draft management agreement that's sent over to us that doesn't really specify what the duties and powers of the management company and the management representative are, right? And that is a recipe for bad expectation and a recipe to fail, right? Because the manager is then in an impossible situation. She or he's the one sitting on site, and they say, Bob or Mary, you should be doing the following, blah, blah, blah. And they go, well, I have no idea why I would be doing that. That's not typically part of my role as the manager. Well, you know, John or Susan, who interviewed, said we did everything soup to nuts. You go, yeah, well, that's nice, but indentured servitude went out in America a long time ago. So I don't do that. So manage expectations through the management agreement, both the expected duties of the manager and the management company, as well as the powers that they will have, right? Administrative resolutions. So administrative resolutions that would be passed by the board can convey powers to management such that the board doesn't have and should not have to deal with these things on a day-to-day basis. What is the kind of the very common example? So if you looked at like an architectural guidelines resolution, right? The manager shall have the power to approve the following modifications so long as they fit within the following guidelines. Where do you see those things? Storm doors, right? The full glass storm door that has nothing on it, it's all white, full glass, full sun view, et cetera, et cetera. Patio extensions. You can have a patio extensions that no more than whatever, 12 foot by 12 foot, et cetera, as long as it's made of concrete or pavers or what have you, the specification. Same thing with deck extension. Those things, if you have a standardized, that's an example of a standardized specification that's approved by the board, and then management is given the power to approve that, unless a variance is requested. If a variance is requested, it doesn't fall into the scope of the approved items, then management would not have the power to approve them, and you'd wind up in front of the board. That makes sense, right? So what should happen to the extent possible is board duties and powers should be conveyed to management, but there should be parameters set around those powers and duties that are conveyed to management, because management truly is the managing agent, is the agent of the board, right? So they act in the stead of the board. The board should not be managing. So that's administrative resolutions, contracts and project management. So depending on the scope of the project, contracts and project management duties and powers can be very complicated from the management side. Why is that? Oftentimes management agreements don't clearly outline what the manager's role is in the project, if anything, right? Because usually the management agreement is talking about day-to-day management. And then what happens is, say several, 3, 4 units burn down. And they say, hey, property manager, we want you to handle the insurance claim. We want you to handle the bidding for the reconstruction. We want you to handle the progress payments for the reconstruction project itself. And the management company often will turn around and say, wait a second, we are happy to do that, but we're going to have to charge you X dollars an hour. We're going to have to staff it with additional people. Or one thing that I don't particularly love is a percentage of the project itself. So I often get a panic call with big projects and they say, Fran, we looked at our management agreement and it says that the management company is going to take 10% of the project cost for project administration. And then they add to that the comment that we've already hired an engineering firm or an architectural firm to project manage this project. Do we still have to pay the property manager? Right, so that becomes real grounds for contention in terms of powers and duties. Does the management company have a right to that fee? Right, do they? I don't know, it depends on the contract. Do they have the power to step in? I would argue no, that they're not doing the architectural issues, but most management companies we'll say, if we are going to do extra work with respect to things like a fire loss, a facade replacement project, a clubhouse renovation, we would have to be, that would be outside the scope of our normal day-to-day management agreement. And therefore, I need to be paid more. The best practice for that would be, and by the way, management should get paid more, and they may even need extra bodies from a staffing standpoint while those projects are going on. What you may want to do is do a side agreement with your management company to say, hey, this is the scope of the project that's outside the scope of your day-to-day management. This is how the association will pay for those additional services. And this is how the project will proceed with respect to that. So, for example, in many associations, especially with roof projects and siding projects, there is a supervising engineer or architect who is actually watching the work, checking on the work, doing punch lists like that and things like that. However, the manager herself or himself has a lot of work to do anyway with respect to things like making sure the landscaping is protected, making sure cars are moved from the parking areas so that the various lifts, et cetera, can get up to the siding, can get up to the building, et cetera. So even though the association has an engineer or architect helping with the project, they still want to empower the manager and give her or him the duty to do certain aspects of the project administration. So what about who would indemnify, defend, and hold the board members harmless? Why would we do that? Now, we've all talked about this. Many of you are board members, and the only way you would serve on a board, right, would be if you were indemnified, defended, and held harmless by the association. Otherwise, you're putting all your assets at risk, right? And nobody wants to do that. Nobody would ever volunteer to do that. It would be nonsense to do that. So, and in line with that, we've talked about this many times, is D&O insurance, directors and officers insurance, that not only does the association have an obligation to indemnify, defend, and hold harmless, that commitment should be backed up by an association's D&O policy. If it's not backed up by an association's D&O policy, it will still be the obligation of the association to indemnify, defend, and hold the board members harmless. In most cases, there are some exceptions to that. And you'd wind up with a special assessment situation for the indemnification obligation with respect to the board members. The next point is, why would we indemnify, defend, and hold the manager or the management company harmless? Same reason. If a managing agent, not the exact same reason, but similar reason, if a managing agent is performing work or incurring obligations within the scope of their agency relationship, which is the management agreement, they should be indemnified, defended, and held harmless with respect to claims within the scope. Why? Because they're not doing it on behalf of themselves, right? They're doing it on behalf of the board, on behalf of the corporation and the association, right? So you could not get reasonably priced management services if the management company had to take the bullet every time someone made a claim against the association and named the management company as part of the claim because they were the agent of the association. This is a big one, you know, for many of you, you've probably seen my article on this. It's a brief article, but in short, it says, strong managers save attorney fees. I say this over and over and over, and notwithstanding this, I see association bid management services into the basement and hire managers working out of the trunk of a Pinto, and they want to know why they have so many legal issues. No offense to the Ford Motor Company or the classic Pinto, but you don't want generally the manager who is working out of the back of a Pinto. You're going to wind up with missed claims. You're going to wind up with missed issues. You're going to wind up with more claims. You're going to wind up with delayed collections. You're going to wind up with issues over and over and over. And the reason I know this, I have no research on it other than my own experience over the past 25 or 30 years, that when an association spends the money and has the board in a solid relationship with management and its ongoing communication, I get much less work. I get much less work. I get fewer claims. I get collection files turned over to me more promptly. I get disputes resolved at the manager level oftentimes before they even hit the board or before they even hit ADR. They're resolved informally by a strong manager. And generally speaking, you'll see fewer lawsuits in association with strong management, which again, when you think about it, it makes common sense. Board members set policy, managers implement the policy. Board members confirm implementation and make adjustments as necessary, right? And that's a long kind of a sentence, I don't know, bunch of words that basically says board members should not be managing. If the board members are unhappy with the way the manager or the management company is serving them, they should make adjustments in either the communication, the scope of the management agreement, how many hours a week the manager is expected to work there. I have a problem in the past couple of years where many associations I'm working with are not engaging full-time management where they have in the past, and instead they're limiting the manager to, quote, 20 hours a week, right? 20 hours a week. And then the manager is expected to work 90 hours a week. And right, so the management company is getting paid a fraction of what they were getting paid before. The manager is running a portfolio of perhaps 6 properties, some managers many, many more properties than that. And she or he is not making any more money, but the demands on a full-time manager have not changed. And I get the phone calls that say, Mary or Kenny are not doing their job. And I say, really? Okay, that's weird because I know her and I know him, and historically she has been really good. And then I come to find out that the management agreement has been reduced to 20 hours a week, and the same output is expected from the manager. So not only bidding management contracts down can hurt the board and hurt the manager board member relationship, cutting the hours without cutting the expectations can really hurt that relationship when it comes to implementing the duties and powers of the board. Enjoy your life. You didn't retire to manage your community, right? High five to that, right? God bless America. Retirement is awesome. And if you find, right, and many of us find this, right, people who retired perhaps too early, right? I'm a ball of energy and I have to sit next to Kathy as she puts in all her GL entries because she may put it under a wrong GL. So therefore I sit next to Kathy all day and watch her put in and make sure she puts them to the proper GL account. No, that should never happen. That should never happen. If you are that energetic, and I'm seeing this more and more actually, if you are that energetic, interested, skilled, and talented, what you may want to talk to someone about is becoming, close your ears, a part-time association manager on a site where you don't live, right? So there are many, we'll say, quasi-retired people who are stepping back, believe it or not, into a second or third or fourth career as part-time managers after a long, lifelong career, and doing 2-3 days a week, sometimes 2, at associations, actually managing and helping out. Because as all of you know, the labor market, the employment market is still crazy tight, and management companies and associations are still looking for good people with experience in the public relations side, if you will, human relations side, day-to-day contact in their community associations. So that's kind of it real quick. I did have a couple questions in the chat. I'll pull that up. Hope I didn't miss anything. Let's see. Is there a ballpark price for a small association to hire a management company? That is a great question. And here's the answer, at least in my world. The lawyer answer. It depends, Michael. So, and I know that sounds like a flip answer, but it really depends, right? So there are 20-unit condominium associations where each unit starts at $1 million. right? There are 20-unit condominium associations in, say, Sea Isle City, Wildwood, Atlantic City, things like that, where virtually nothing is done, right? It's a summer place and people just go there. There's not a lot of work. It's 3 months of the year where it's intense. Very different animals. So it really depends on the animal. It depends on the association itself, how much common elements are there, how much work is anticipated, whether you want to go with a la carte management, for example, or consistent management. Do you need a project done and that's why you need management? And day to day, you're small enough to do it yourself. So a lot of these, you know, 5, 6, 7, 10-unit condos down at the shore area are self-managed, and they don't get into management companies in particular unless there's a project. And there are a number of management companies who will manage on a project basis. So they'll come in and help you do a re-roofing project, a re-siding project, a repaving project. But day to day, you're not paying them on a monthly basis. There, just as an aside too, there are many management companies that will do what they call financials only. So they won't even call that a management agreement. They'll call that more or less a bookkeeping agreement, whereby the association is not getting a person to deal with all the nonsense. The board deals with all the nonsense itself, but the management company receives the payments, sends out invoices, sends out payment things, and then provides financials on a monthly basis. So that's also a way where smaller associations get the benefit of a big management company. I shouldn't even say big, perhaps a sophisticated management company with software systems and the like, and doesn't have to pay huge fees. Is not the board's job to set the agenda for the community manager? Yes, yes. I don't know if I'd call it the agenda, Carl, but I would set the policy. You know, this is what we expect. This is what we're looking for. I know, Carl, you have a world of experience yourself, and you're a guy who I am sure one of these management companies would hire in a heartbeat if you ever want to go back to work. But I see you laughing at me, so sorry. So board should set policy. The manager should do the day-to-day tasks. When a homeowner buys a property, must they be given a copy of the governing documents, bylaws, rules, and regulations? We have many homeowners that say they have never gotten it. Also, should they be able to have access to this before signing on the dotted line so they know what the rules and regulations are? So that's Alba. Hi, Alba. I didn't see you out there, but haven't seen you in a while either, Alba. You must be on another screen. But nice to hear from you, Alba. So the answer is yes, Alba. The proposed legislation that is aimed at addressing the Champlain Towers issue actually mandates that the prospective purchasers and owners be giving complete copies of the public offering statement and other documents before that, including a structural assessment report by an independent engineer, whether that's a governmental engineer or a third-party engineer hired by the governmental entity. So I argue generally that every association should have the declaration, master deed, bylaws, et cetera, public offering statement prior to closing. But to date, most people did not have that prior to even getting through the attorney review period when they're buying a unit. However, this is where things get sticky among the lawyers. Often when an issue comes up and a new homeowner says, Mr. McGovern, I never got my public offering statement and I didn't realize I couldn't park on this and that and the other thing. And I say, well, you might want to talk to your closing attorney, because more often than not, the declaration, master deed, and bylaws are recorded in the county clerk's office, and they were pulled as part of your closing attorney's closing title packet. But unfortunately, many clients do not receive that from their closing attorney, right? So the closing attorney actually had it prior to closing, but they didn't review it with the prospective buyer. And I'll put in a plug for the closing attorneys out in the world. We don't do real estate transactional work, but I'll put a plug for the closing attorneys out there. They are not paid enough for the torture they endure. They are not paid enough for the torture they endure. So for all of you who are online who are realtors or mortgage people or closing attorneys, God bless you, because it's a long suffering thing oftentimes, and oftentimes closing attorney will be paid $1,000 for a closing and spend $5,000 worth of time going back and forth for the various parties, looking at inspection reports, et cetera. So that's a good point, Alba, and it is in the pending legislation. And just as a footnote, I will talk about the pending legislation going forward. The pending legislation, again, it's Senate Bill 2760, is supported by the Community Association Institute right now. And as you know, every piece of legislation, not every section is agreeable to everyone on the planet, but politics is generally the art of the possible rather than the art of the perfect. So thanks, Alba. Carl, yeah, most of them have online. So that's what Carl said in response to Alba's question, is most associations do have their master deeds, declarations, and bylaws online, along with the rules and regulation. As you know, I'm a huge proponent of transparency. I like to tell my associations to put as much as possible online. Master deed, bylaws, rules and regulations, annual budget, audit, things like that. The proposed legislation will also be talking about reserve funding obligations and what associations have to do to meet reserve funding obligations. So that is going to be a much more important topic in terms of disclosure of where your reserve fund is vis-a-vis your reserve fund needs. So this legislation, not only is it aimed at regular inspection of structural issues, but also proper funding of reserve funds necessary to fund structural issues. Should the judiciary or the association have a schedule of fines for rules? Example, not picking up after your dog, drinking at the pool, smoking in the common areas. Yes. So yeah, Bill, thanks. Yeah, you should have a schedule of fines. Most associations have a one fine, $25 an incident, $50 an incident, what have you. And it's a continuing fine until the violation is remediated. So if you have $100 fine in your schedule of fines for, say, for example, not putting in the right storm windows, that fine would accrue on a daily basis until the violation is cured. Yeah, obviously you have to offer them ADR prior to the fine becoming due and payable, but the fine would accrue on a daily basis until the violation is remedied. The issues with as you know, the issues with picking up after dogs, fines for that, drinking at the pool, smoking in the common areas, is the enforcement part of it. You know, proof. Is that your dog poop or my dog's poop, right? And we even have services now, believe it or not, that have genetic testing of dog poop, and there are associations that do it. None of mine do, but there are associations that do it. Sounds a little crazy. Same thing with the drinking at the pool. How do I know that Bob with the cozy is downing, you know, Bud Light as opposed to lemonade? Am I going to go up to Bob and say, "Hey, Bob, let me sniff your can," which nobody should be sniffing cans. Speaking of dogs, but the question is, how do you enforce that? How do you enforce that? There are situations, right, especially with alcohol at the pool, when you have a 16-year-old lifeguard who either is not confident enough or is with a crowd that can't deal with alcohol-related behavior, and in today's world, marijuana-related behavior. And the association may have to get the manager involved to back up the lifeguard and or close the pool given bad conduct. So things like the swimming pool conduct or smoking pot in the common area often really kind of go beyond fines. I mean, fines are part of it, but you usually wind up in ADR with those issues. You often wind up with the manager, and you often wind up at the Judiciary Committee level. Our association is now facing a significant balcony repair issue, so we're very interested in any relevant discussion regulations that are most current and applicable. So Norman, this, like I said, the pending regulation has been, I think, through two committees, is in a third committee now. They're expecting it to be reported out of committee, which is a good thing. But you should pay attention to that. If you send me an email, I will send you a copy of the pending legislation. Again, it has not been passed, has not been voted for in the legislature, not been voted on, and has not been signed by the governor. But because there are as you know, there are various interest parties. It doesn't just apply to community associations or condominium association. It will also is projected to apply to builders in new construction. It's also projected to be applied to apartment buildings and apartment building owners. So there are some conflicts between the various parties as to, for example, some builders apparently are concerned about possible costs. Some apartment owners are concerned about possible costs. And I think the Community Associations Institute Legislative Action Committee, which is awesome, they do a great job and a lot of work, is trying to smooth those things and work together with the various interests to get this done, so we don't have a Champlain Towers or we don't have a Seattle City issue as well. So, but you should keep your eye on the ball there, Norman, especially if you're doing a significant balcony project. How do you manage board members who are getting too involved with day-to-day activities? So getting too involved with day-to-day activities is really hard. So there's a couple things. If you're the property manager, what I believe should happen is the property manager, rather than confronting that issue herself or himself immediately, should report to their superior. So if they have a regional manager, they should report the issue to the regional manager. Oftentimes, management at the corporate level are a little reluctant to take a hard line against a board member who is, well, let's see, sitting in front of the manager all day in the management office and taking up the manager's time and then complaining that the manager gets nothing done. They're reluctant to do that, obviously, because they want to keep the contract and get it renewed and be happy with all the board members. Therefore, the second step in my mind would be the manager and the regional rep, as best they can in a very diplomatic way, reach out to other board members and ask those board members if they could work with them in, let's say, modifying the behavior of the board member who can't seem to set boundaries or respect boundaries. It's very tough politically, right? It's very tough politically, very tough diplomatically, because what I have found is that behavior sitting in front of the property manager all day in the management office is compulsive and just doesn't stop no matter who says what. It will back off at times for, say, 3 weeks to a month, and then it will start up again. And then it'll back off for a while, and then it'll start up again. So it's a real challenge for board members and the management company to let's say, modify that type of behavior. That behavior I have found has always been well-intentioned. I'm here to help Fran. I'm trying to take the load off her plate or his plate. I'm assisting, and that may or may not be true, but I have found more often than not that what the manager will say is, listen, I've been a professional manager for a long time. I can do the management job. I do not want to be somebody's administrative assistant, right? I don't want to be that person. I'm a professional. I want to do my job. I want people to respect me. I don't want someone sitting in my office and telling me that I need to do this, that, and the other thing, and they expect me to fold letters and stuff envelopes. That's not my job. So it's a fine line, though. It's a challenge. All right. So hey, Cheryl says you got a job for you, Carl. Where are you? Carl, I got a job for you. Email me that resume, okay? I got a job for you. Question on resolution enforcement. Our management company has office hours from 9 to 3:30, Monday to Friday. So most parking violations happen overnight and weekends. They ask for photos, and most homeowners are uncomfortable reporting their neighbors. Any suggestions? And thanks, Kathleen. So the biggest challenge with parking enforcement is, when on-site management is there, number one, whether you're complying with the Predatory Towing Act. The Predatory Towing Act has a series of guidelines that the association must comply with before towing cars. And I have found that towing cars is the best means of enforcing parking regulations, if not the only form. So it's very challenging. As far as homeowners being uncomfortable reporting their neighbors, I never feel that way, unless we have intimidation, harassment, and bullying. But if it's just like, hey, I like Bob next door, and he keeps parking in my assigned parking spot, well, Bob is victimizing you. Bob is victimizing you. You're the victim. You shouldn't feel bad about telling the association that Bob keeps parking in your assigned spot. We do have cases where, Bob or Kathy or Joe are bullies. So the whole building, for example, is afraid of that person. They're intimidating. They yell at people. They, flat tires appear in the parking lot, things like that. So that's a different issue. And most recently, we've been talking about cameras with respect to those types of enforcement issues. But as for parking itself, you would have to get a parking and towing resolution. You would have parking and towing signage. You're supposed to have a rep on site and available. You don't have to be there as the tow company picks it up, but generally speaking, you really have to speak to your attorney about parking and towing resolution and a contract with the towing company. It was much simpler prior to the Predatory Towing Act. Should a management company have a book of best practices that it shares with all its clients? For example, COVID policy, sample rules and regulations, current changes in legislation, recommendations to implement bylaw changes in light of the prevailing conditions. So Muriel, many, I would say probably all management companies will do, I guess what you'd call a board training session, kind of like what we're doing right now, but more specific to like a board training session, and talk about issues generally. Hey, welcome to the community. We're new here. Thank you so much for hiring us. I've reviewed the association's books and records so far, as well as the governing documents, and I find the following concerns. What are your concerns? What are your pain points? This is what we see is happening in the greater community association world. Like, so for example, this structural defect legislation coming down the pike. So management companies are generally involved in that. There's usually a discussion. Management companies often bring me in for informational sessions with their boards or new clients. And I just talk about issues generally, just like this, what's coming down the pike in legislation, what we see out there in terms of, say, for example, structural issues, violations issues. As you know, I've been dealing with mental health issues in a lot of community associations lately, very tough topic, but kind of the hot topic. So the answer to your question is yes, Muriel, but not typically in a formal way day to day. It's a back and forth. Aldi, aren't the realtors supposed to disclose, supply the supporting governing documents prior to the sale being completed? Yes. So, I have found that typically the realtor does not provide a governing document package or a public offering statement. Certainly in new construction, if you're buying a new unit, the developer and the developer sales rep are obligated to give you the full public offering statement, which includes everything else. But often realtors do not and are not the ones to provide that. At least that's been my experience. I know there are a lot of realtors online. If you have any further feedback on that, let me know. You mentioned ADR. Is there a necessity to offer ADR for something simple like the wrong paint color? Absolutely. Absolutely. So if someone were to paint their house the wrong color, ADR is the same. I shouldn't say the same, very similar to a traffic ticket or a parking ticket. You know how we all get our parking tickets or our speeding tickets that say, license number, blah, 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 you were doing 65 in a 55-mile-an-hour zone. This means you have a fine of $250. However, you have a right to come to municipal court on April 15th and contest this fine. If you do not appear on that date, the fine shall become due and payable, and you will have to pay it at the municipal clerk's office. What that's called in the law, it sounds fancy, but it's not fancy. It's called due process, which is a notice of the issue and a right to be heard. Notice and a right to be heard. So in community association world, it's a little different because the right to be heard is a right to ADR, which generally means mediation, not like a municipal court judge who drops the hammer on you. but it's notice of the violation, notice of the potentially due fine, and a right to sit down and have the either ADR committee or the mediator try to work it out. The attendance and participation in ADR is not a prerequisite to fining, okay? It's the opportunity to participate, just like the municipal court ticket. It's the opportunity to come in before the municipal court judge and say, Judge, you know, I parked in the handicap parking spot because my wife was having a baby and there was nothing I could do. There was no spots. And that's why I parked there, Judge, and please don't give me the ticket. So you can argue your case. So it's very similar. If the balcony is the homeowner's responsibility, is the association liable if anything to happen to it structurally? This is a tough issue, right? Because if the association is responsible for maintaining, repairing, and replacing the balcony, there's an argument that says the association doesn't have to do anything, not my problem. The problem with that, though, is there is case law in New Jersey that says at a minimum, the association is in the best position to warn unit owners of known safety hazards and issues. You see what I'm saying? And people have talked about that in the past. That's the dishwasher case where the line broke and the association knew that there were dishwasher common, even though it was the unit owner's dishwasher, there were common problems with that manufacturer of the dishwasher where that line broke all the time. And even though it was a unit owner item, the association was aware of it and never sent a flyer out to the unit owner saying, listen, this is your problem. You got to fix it. It's going to damage other people. So a duty to warn is out there in court cases. The other issue is, especially with life, health, safety issues, like a deck that may be deteriorated and in danger of collapsing, is generally the association has a provision in its governing documents that says, if the association finds that a unit owner element is not being properly maintained, repaired, and replaced, and the association notifies the homeowner to do it within a certain period of time, and that is not done during that time period, the association can undertake to make the repairs and charge the unit owner back. Otherwise, we would have people falling off balconies all over the world and people getting killed, which is not a good outcome, right? So if you have a situation where unit owner, balconies, decks, what have you, are not being repaired, replaced in a timely manner, the association would typically send out a notice with an offer of ADR usually as well, unless it's emergent, and undertake to do it itself and charge back the unit owner. The big problem with that, Alba, is many associations don't have cash flow to advance the money for those deck or balcony renovations, because as you put out there in your hypothetical, the association didn't budget for repairing the balconies and decks and what have you. So the association winds up having to find a source of revenue to do the repair. We've even had balcony cases. I had a collapsed balcony in New Brunswick years ago where, thank God, nobody got hurt. But people refuse to listen to the association that you cannot go out on your deck. And what we ultimately had to do with one deck was a 2x4 was screwed in the slider door so they would stop using their deck, which also raises the issue about fire egress. So be careful before you start screwing doors shut. We don't want to do that if we don't have to, especially if the slider is used as a means of egress for fire safety. Let's see. Oh, we got another. There we go. There's Carl. Carl, get that resume over here. You're popular today. Are handicap sidewalk ramps the responsibility of HOA, even if the roads are dedicated to the township? Even if the roads are dedicated to the township. I'd have to look at that more, George. I don't want to give you a real answer on that. My question would be, does the association own the sidewalks? Even though the handicap ramps are within the right of way, I'd have to sit down and take a look at that and parse the duties. I don't know. I'd have to see what the dedication resolution says. I can say this. Many municipalities have gone the route now of, I'll say, foisting the obligation for maintaining, repairing, and replacing sidewalks onto homeowners. So it's a real mixed bag, especially with respect to liability. So George, I don't know if you were on this when I told you I had a case where there was an engineer, a guy in a wheelchair, and a lawyer who had a cottage industry going around the state in a van. The gentleman in the wheelchair would test all the handicap curb cuts. And if they found them deficient, they would then sue the association or the apartment complex or the bar or what have you under the ADA or the Fair Housing Act. The engineer would write the report and the lawyer would sue, and they would all make money. So you got to be careful of a couple things. Number one, who's responsible? Number two, you have to be careful of liability because you have to comply. We do night and weekend inspections for parking issues. Thanks, Chip. So Chip's a property manager, and he says we do night and weekend inspections for parking issues and violations. That's great. I mean, but your management company would typically charge for that on an a la carte basis, unless you negotiate an increased rate in your management agreement. Nicole, great subject matter. Thanks, Fran. I like that. Positive feedback. Awesome. Replying, we do, there you go. Night meetings. We do night meetings. We do night meetings. Same question, just started to enroll in January. So we want to get your great ideas. Oh, thanks, Kathleen. That was nice. Realtors can ask management if there are any assessments, etc. So this is an interesting issue Marcia raised. Realtors can ask the association if there are any assessments pending. So that she means, I'm sure, special assessments. So I would say yes, realtors should talk to the manager about that. The manager should also think about what is coming down the line. Some of these things get quite complicated from a timing standpoint. So the association, say, for example, the association's board is talking about a very significant special assessment for, so let's say, balcony replacement, and somebody goes to contract. But that, whatever, let's say $50,000 special assessment has not been voted on yet, right? Has not been voted on by the board yet, but it's out there. Everyone in the community knows about it. And they go to close, and the management company issues what's called an estoppel certificate that says this is what's due on the unit, this is what's payable in terms of capital contributions, et cetera, and then the person closes. The board votes to pass the $50,000 special assessment, and the person turns around and goes, wait a second, I just got an estoppel certificate that says this is what's owed. You guys ripped me off. I'm not paying this $50,000. The question, though, is, was it due and payable at the time? And the answer would, in that case, would be no. So it wasn't due and payable at the time. But I can tell you that buyer is going to be really, really unhappy with their realtor, with their lawyer, with the property management company, et cetera. So those issues, I think, I don't know if Marcia, I can't remember, Marcia, or you are a realtor, right? Yeah, so yeah, thanks, Marcia, that's great. So the good realtors, like Marcia, would actually have that conversation, right? Would have that conversation because you got to put the cards on the table. Otherwise, you're going to have really bad blood. Many buyers and sellers adjust that as part of the closing, right? So we know there's a special assessment coming down the line. We're going to put something in escrow, or we're going to adjust the purchase price based on the assessment. Let's see. Has there been a change in who pays for ADR? Thanks, Jewel. My position has never changed on who pays for ADR. The Twin Rivers decision, one of them suggested that the association has a right to impose the costs on the people who are participating in ADR. I have never agreed with that decision. I think that decision is wrong in that aspect. My reading of the statute is that the association shall provide alternative dispute resolution. To me, that means the association must pay for it. And in addition to that, the reading of the statute, what it often happens when you try to impose the cost of ADR on the parties themselves is you wind up with a case within a case, because then the person says, I'm not paying for ADR. I'm not paying for a mediator. That's ridiculous. And instead of solving a problem, you've created another problem. And it just turns into an endless loop, which you don't want. So I'm always an advocate of the association paying for ADR. let's see. And replying to realtors. Has there been a change? There, we got that. Aren't balconies usually limited common property? So thanks, Cheryl. So balconies can be limited common property. They can be part of the unit. They can be unit owner items too, but often they are limited common property. You're right, Cheryl. Is CAI always allowed to hear a case presented to them from any association upon request, or is there a time when the association must use the association's ADR only? So it's interesting. You mentioned that I'm involved. That's from Sal. I'm involved in a litigation over this particular issue right now, so I should probably hesitate to render an opinion on this. But so generally speaking, the association may have an ADR resolution. The association may have a judiciary committee provision in its bylaws or governing documents, like many of you do have. The question is, if you don't have volunteers or people able and willing to fulfill those roles specified in your governing documents in your resolution, what do you do? Right? You can't force your members or the community next door to volunteer for your judiciary committee or ADR committee, right? So the statute, in my opinion, still compels you to make ADR available to the disputants. So I advise associations to proceed in ADR in a reasonable fashion as required by the statute and as possible, again, existing in the world of possible and reasonable, rather than in a fantasy world where you would have to compel people to volunteer. Let's see, almost done, I think. CAI has trained mediators. There is a form to complete the request ADR and pay the fee. That's right. Thanks, Cheryl. So CAI mediators are great. They're often much cheaper than other mediators out there. I volunteer as a CAI mediator myself, and it's very affordable compared to other mediators most time. My first call here, and love it. Thanks so much, Fran. Thank you, Kathleen. I'm glad you could attend. Assessments should be included in the disclosure form. So you're right. So assessments would typically be noted in the estoppel certificate that the realtor and the closing attorney get. That's true. I understand that. My question is whether or not an association must use the association's ADR, or can an association use CAI whenever needed without having to use their own ADR committee? So Sal, I'm not going to give you an opinion on that right now because I am in the middle of a litigation over that. And you know, if we have to, I guess we could speak separately sometime. But that's a topic of a litigation I'm involved in right now. So I'm going to pass. I think that's the first time in 4 years that I actually passed on a question. So Sal, you got me. There's Bill said he needs Chip's Hoover email address. Would like to share ADR hearings with other communities. Is this okay? Yes, Sal, absolutely. So there are many associations. Volunteers from the community next door will do ADRs for the people next door. So you just have to have an understanding of how that works in your particular circumstances. But so wow, that was great. I enjoyed it. I hope I didn't talk too fast. I hope I answered your questions. I hope you found it interesting. And I hope you have a great weekend. I hope the weather stays nice and warm. So have a great weekend and thank you so much. And I will see you next month. Thanks for coming. Bye-bye.